Good afternoon, Vande Mataram, Jai Hind. How are you all? I hope you have watched the previous videos before watching this video. And like, subscribe to the channel and click on bell icon to get the notification of the new videos on time. Today we are going to learn the Dpsp, Directive Principles of State Policy, Day 6 of Indian Polity. So without wasting time, let's start. The Part 4 of Indian Constitution talks about Directive Principles of State Policy, Article 36 to 51. No court may enforce the provisions contained in this part, but these principles are fundamental to the country's governance and it is the state's duty to apply these principles to lawmaking. They have been mentioned in the Part 4 and covers the article from 36 to 51 of the Constitution of India. We have taken the Directive Principles of State Policy from the Irish Constitution, and the Irish Constitution is taken from the Spanish Constitution. Many of the leaders in the political have taken the part of the Directive Principles of State Policy in this speech because they are non-justiciable in nature. The Directive Principles of the State Policy denotes the ideals that the state should keep in mind while forming the policies and enacting the laws. That means if the state government or the union government is forming any type of policies and laws, they have to keep in mind the principles of the state policy given by the Constitution of India. The Dpsp are not enforceable, and in case of violation, the person cannot move to the court of law. Like I said, the Dpsps are non-justiciable in nature, so if anyone violated these principles, they cannot go to the court against the violation. The Supreme Court said that although the Dpsp are not enforceable, yet they should not be avoided, and all the government policies should be made keeping them in mind. The Supreme Court said that if any state government or the union government is making the policies, then you should not avoid the Dpsp and also keep in mind and make according to it. They aim the realization of the welfare of the state. Then come the features of the Dpsp. They are also known as the novel feature of the Constitution. They are taken from the Irish Constitution, like I said. They similar to the instrument of instruction mentioned in the Government of Indian Act 1935. Together with the fundamental rights, they are termed as the consensus of the Constitution. The fundamental rights and the Dpsp combined together are known as consensus of the Constitution. The Directive Principles of the State Policy denotes the ideal that the state should keep in mind while formulating the policies and the laws. The Dpsps constitute a very comprehensive economic, social and political program for modern democratic state. They aim at realizing the high ideals of justice, liberty, equality and fraternity as outlined in the preamble to the Constitution. They embody the concept of the welfare of the states. In short, Dpsp are in the Constitution of India for the welfare of the state and the people, the citizen of the India. The seventh one is the Directive Principles are non-justiciable in nature. That is, they are not legally enforceable by the courts for their violation. Therefore, the government, central, state and local cannot be compelled to implement them. Nevertheless, the Constitution, Article 37 itself says that the principles are fundamental to the governance of the country and it shall be the duty of the state to apply this principle in making. As said that earlier part as well. The provisions of the Directive Principles are broadly classified into three parts: the Socialist Principle, the Gandhian Principles and the Liberal Intellectual Principles. In the Socialist Principle, there are various types of article. We will see about that. The Article 38, Article 39A, Article 41, Article 42, Article 47. In Gandhian Principle, there are some articles like Article 40, 43, 47, 46, 48. And the Liberal Intellectual Principle have the articles 44, 45, 48, 48, 49, 50 and 51. So we will see them one by one. Some important articles in Dpsp are to promote the welfare of the people by securing a social order permitted by justice, social, economical and political, and to minimize the inequalities in income, status, facilities and opportunities. To secure the right to adequate means of livelihood for all citizens, the equality distribution of material resources and the community in the common good, prevention of the concentration of wealth and means of production, equal pay for equal work for men and women, preservation of the health and strength of workers and child against the forcible abuse, and opportunities for healthy development of children, that is covered in Article 39. Then comes the to promote equal justice and to provide free legal aid to the poor, Article 39A. This was added by the 42nd Constitution Amendment Act 1976. I will tell you all the Constitution Amendment Act at the end of the upcoming videos, all in one manner. So you will get the all Constitution Amendment Act in one go. To secure the right to work, to education and to public assistance in case of unemployment, old age, sickness and disablement, to make provisions for just and human condition for work and maternity leave, that is in Article 42. To secure a living wage, decent standard of life, social and cultural opportunities. Also the step to secure participation of workers in the management of the industries, to raise level of nutrition and the standard of living in Article 47. These are covered in the socialist principle of the Dpsp. Then comes with the to organize the village panchayat and give them the necessary powers and authority, comes in the Article 40 that we will be discussing the latter words. Then there are some articles to provide early childhood care and education for all children until they complete the age of 6 years, that is in Article 45, also amended by the 86th Constitution Amendment Act, that the education for all children until the completion of the age, which has been amended by the 86th Constitution Amendment Act. To separate the judiciary from the executive in the public services of the state, Article 50. Then comes the Article 51, to promote international peace and security, to maintain just and honorable relation between the nation, to foster respect for international law and treaty obligation, and to encourage settlements of the international dispute by arbitration. Then comes the Article 38. Article 38 deals with to promote the welfare of the people by securing a social order by justice, social, economic and political, and to minimize inequalities in among status and facilities and opportunities. Article 39, to secure the right to adequate means of livelihood for all citizens, to equitable distribution of material resources of the community for the common good, to secure a prevention of concentration of wealth and means of production, equal pay for equal work for men and women and children against the forcible abuse, the opportunity for healthy development of children. 39A, the equal justice and free legal aid. 40 deals with the organization of village panchayat, that comes in the Gandhian principle. The right to work, to education and to public assistance in certain areas. Article 42, the provisions for the just and human conditions for work and maternity relief, that we have discussed earlier as well. This 43, 43A, 43B, the Uniform Civil Code, that we have also discussed. The new directive principles, the 4 new directive principles were added by the 42nd Constitution Amendment Act 1976, that are to secure opportunities of the healthy development of the children, Article 39. Then, to promote equal justice and to provide free legal aid to the poor, Article 39A, to take steps to secure the participation of workers in the management of industries, Article 43A, to protect and improve the environment and to safeguard the forest and the wildlife, comes in the Article 48A. All the 1, 2 and 3 comes in the socialist principle, and the 48A comes in the liberal intellectual principle. Then comes the the 44th Constitution Amendment Act 1978 added Directive, which requires the states to minimize inequalities in income, status, facilities and opportunities. Article 38. The 86th Constitution Amendment Act 2002 changed the subject matter of the Article 45 and made elementary education a fundamental right under the Article 21A. The amended directive asked the states to provide early childhood care and education for all children until they complete the age of 6 years. That has been amended by the 86th Constitution Amendment Act. This Amendment Act says that the state will provide the early childhood care until a child attains the age of 6 years. The 97th Constitution Amendment Act 2011 added a new directive which requires the state to promote voluntary formation, autonomous functioning, democratic control and the professional management of the cooperative societies, for Article 43B. The Article 43B and the 97th Constitution Amendment Act 2011 deals with the cooperative societies that we will be discussing later on as well. The directives outside the Part 4. There are some other directive principles contained in other parts of the Constitution apart from that in Part 4. The Article 335 in Part 16, the claims of the members of the Supreme Courts and the SCs and STs shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of opportunities to service and post in connection with the affairs of the Union and States. That means it deals with the SCs and STs participation and maintaining the efficiency in the administration for the seats and the post services for them. The Article 350A in Part 17 deals with it shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in mother tongue at the primary stage of education to children belonging to the linguistic minority groups. That means the state will give the early primary stage of education in the mother tongue to the children belonging to linguistic minority groups. Article 351 in Part 17, it shall be the duty of the Union to promote the spread of the Hindi language and to develop it so that it may serve as the medium of expression for the all elements of the composite culture of the India. That means it is this duty of the Union government to promote the Hindi language to spread among all the levels of the citizens of India for the betterment of the country. The conflict between the fundamental rights and the Dpsps. The Supreme Court in the state of Madras versus Champukma 1951 case held that in case of any conflict between the fundamental rights and the directive principles, the fundamental right would prevail. That means the fundamental rights are always greater than the Dpsp. But the Dpsps cannot override the fundamental rights. However, the court also held that the fundamental rights could be amended by enacting the Constitution Amendment Act. That means the fundamental rights can be corrected anytime by the Constitution Amendment Act. As a result, Parliament made the First Amendment Act 1951, the Fourth Amendment Act 1955, the Seventh in 1964 to implement some of the Dpsp directives. In Golaknath versus the state of Punjab 1967 case, the Supreme Court held that the Parliament cannot abridge or take away any of the fundamental rights for the implementation of the directive principle. That in this case, the Supreme Court clearly says that the fundamental rights cannot be taken away for the implementation or having the implement of the directive principles on the citizens. Then the Parliament enacted the 25th Constitution Amendment Act 1971, which inserted the Article 31C, which said that the law seeking to implement the socialist directive principles specified in Article 91B and C shall not be declared void on the grounds of violation of fundamental rights conferred by Article 14, 1931, right to property. Then the law declaring to give the effect to such policies cannot be challenged in any court. The Supreme Court in Keshwanand Bharati versus the State of Kerala 1973 case declared the first provision of the Article 31C to the Constitution and valid. However, the court declared the second provisions of Article 31C as unconstitutional and void on the ground that it took away the power of judicial review from the courts, which is the part of the basis of the Constitution. Then the 42nd Constitution Amendment Act 1976, and what happened in that Article 31C provided that any law enacted by the state to give the effect to one or more directive principles, and in the process if the law violated any fundamental rights and cannot be held constitutional. That means under this article, if state enacted any law for the directive principles but it altered the fundamental rights, then it cannot be held unconstitutional mostly on this ground. The right to property was abolished as the fundamental right by the 44th Constitution Amendment Act 1976, as I told earlier as well. Thus, the directive principles were once again made subordinate to the fundamental rights, but the fundamental rights conferred by Article 14 and 19 were accepted as subordinate to the directive principles in the Article 39B and C. Therefore, the fundamental rights enjoy supremacy over the directive principles. But the Parliament can amend the fundamental rights for the implementation of the directive principles by not destroying the basic structure of the Constitution. That means fundamental rights always have the upper hand over the directive principles, but Parliament have a strong hold and they can amend the fundamental rights anytime for the implementation of the directive principles. But the Parliament never destroy the basic structure of the Constitution. This is the one condition that they have given. Then the difference between the two fundamental rights and the directive principles: these are negative as they prohibit the state from doing certain things. These are positive as they require the state to do certain things. They are justiciable, they are non-justiciable. They aim at establishing political democracy in the country. They aim to establish social and economic democracy in the country. They have legal sanctions. They have legal and political sanctions. They promote the welfare of the individual. Hence, they are personal and individualistic. They promote the welfare of the community. Hence, the societarian and the socialist. They do not require any legislation for their implementation. They are automatically enforced. They require legislation for their implementation. They are not automatically enforced. The court are bound to declare the violation of any of the fundamental right as the unconstitutional and invalid. The court cannot declare a law violated of any of the directive principles as unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to directives. In short, directive principles of state policy are there for the welfare of the states and the citizens of India. We have taken the directive principle of the state policy from the Irish Constitution. It is in the part 4 in the articles 36 to 51 of the Constitution of India. This you have to be remember. And one more thing, directive principles are non-justiciable in nature. These are the things that you need to remember for your exam point of view. Also, there are few criticism that there are no legal forces, illogical arrangement, conservative constitution conflicts are there. These are some criticism given by some people over the directive principles, that we can say so. So that's it about the directive principles of the state policy. Tomorrow we will study about the fundamental duties, a short chapter to learn that we will see tomorrow. That's it for today. We will meet tomorrow at the same time, and don't forget to like, subscribe and share, and click on the bell icon to get the notification on time. Thank you.